Hello and welcome to Rights and Recourse, a program that tackles issues affecting your rights and matters of legal recourse. Thanks for joining us and wishing you all a great year. My name is Dumile Matez. Remember, you can also be part of our discussion today by tweeting us at Rights Recourse or calling our studio line on 011 714 5497 or 5498. You can also SMS your views by sending the word recourse to the number 34025. Alternatively, email your thoughts to Rights and Recourse at sabc.co.za. The collapse or success of any case depends largely on the evidence presented, whether it is in a hearing, mediation process, or in a court of law. And many remember how the quality of evidence played a crucial role in the outcome of some of the recent high-profile cases in South Africa. But before we get into the discussion, let us first view this insert.
How important is it really to be a credible and a reliable witness in a court? We ask ourselves, the protection of a crime scene, why is it important? And does it matter as a form of evidence? Today we're here to meet Ronald Bobrov, a legal expert. Come with me. Good day, how are you, ma'am?
Good, and yourself?
I'm fine. I'm here to meet Mr. Bobrov. Good afternoon, sir.
Hi, nice to meet you.
How are you?
Yeah, excellent, thank you.
Can you tell me now, how important is the evidence in building up a strong case?
Well, it's the evidence that makes the case.
Yes.
If you don't have the evidence, and you don't have the correct evidence, and perhaps equally importantly, if the evidence is not properly prepared, you're not going to win the case. So evidence is everything.
Having watched some of the prominent cases in 2014,
Yes.
you will know the cases that I'm referring to.
Yes, yes.
Can you just show us how evidence came into play in those?
For example, in the Pistorius case, an expert, a geologist, gave evidence about the transmission of sound. I don't understand how that could happen, because surely you'd want someone who's an expert on sound. In the Dewani case, where it was important for various reasons to know the length of the arm of the accused with regard to where the pistol would have been held that caused the death of the deceased. The measurement was taken from the armpit to the tip of the fingers. Now, you don't hold a gun at the tip of your fingers, you hold a gun centre of your palm. And it's that kind of detail that one's got to be so careful about. And once again, it's expertise.
In my view, Mr. Tonga's evidence is of a very poor quality, but his evidence is of such a poor quality that one simply does not know where the lies end and the truth begin.
Well, in South Africa, the system, my friend, is quite skewed, and it's quite utopian. It does not conform, with the conventional standard of the law of evidence. So it's quite simple that one can do. I mean, we've seen it on TV, especially, like previous speakers has just indicated. In South Africa, if you got money, then at least you've got justice. Justice is money. That's the twin aspect of the equation. That's what it means.
What kind of evidence is not admissible in court?
Well, any evidence which is improperly obtained. So, for example, if a confession is extracted from an accused by way of torture, the courts will not admit that. Or, for example, the formalities in the Criminal Procedure Act aren't adhered to. Where a person wants to make a confession, there's certain formalities. The person's going to be brought before a magistrate, got to be warned about his or her rights, and there's a very formal procedure in accordance with our Constitution that has to be followed. If that's not done, then that admission will not be admissible.
Why is it important not to tamper with the crime scene? And what happens if it gets tampered with?
So what's supposed to happen is the crime scene should be immediately secured as soon as the police get there. They should cordon it off, and they should make sure that no one is allowed to enter the crime scene. We've had cases, tragically, where loiterers come into the crime scene, they take the deceased's watch, move objects around, come on with shoes that have got mud on them, and create extra footprints which might obscure footprints of shoes or shoe prints. So the crime scene must be properly secured. It's essential that the police be properly trained. And unfortunately, we have many cases where successful prosecution is not obtained because the evidence is not properly secured. And on cross-examination, it's clear that it could have been tampered with, and therefore it's unreliable.
How important is it to choose the right attorney that will represent you in court?
And if you are an accused, in a criminal matter, you need to go to an attorney that specializes in criminal law.
Go well.
Thank you.
Okay, thank you.
Welcome back. Thank you to Sandile Hlangani there for that report. To discuss today's topic are Advocate Zola Majavu, a legal expert, Major General Pitso Ramatswili, Acting Divisional Commissioner Detectives from the South African Police Services, and at our Pretoria studios we are joined by Brigadier Liseja Mangale, who is the Head of Forensic Database Management at the South African Police Service. Gentlemen, good afternoon and welcome to Rights and Recourse.
Good afternoon.
Probably the first question I should ask, anyone can venture to answer this question. Probably I'll ask you, Mr. Majavu, to first take a first part on it. Probably the first question one should ask is, what is evidence?
Evidence are objective facts that tend to prove or disprove the occurrence of a particular incident. So whatever that has to be said about a particular incident, when it is offered in a court of law under oath, it becomes evidence.
Now, one of the, you wanted to add something?
Yes, and I'm saying, and there are different types of evidence, but I think largely and simply put, evidence are those facts that are adduced in court under oath by a witness, and collectively viewed, it is referred to as evidence.
Once again, there is something else that I wanted to put to you, is that it has been said that the onus is on the state to prove the guilt or innocence of the accused. Should the state and the police make sure that their case is watertight? And how do they do that?
Absolutely. I think as a starting point, when the state prosecutes a person, it can and must only do so having satisfied itself that the evidence that it has at its disposal is such that it can lead to a successful prosecution. Anything short of that would lead to an acquittal and therefore undermine, the community's confidence in the justice system. So it goes without saying that the start of any case is wholly dependent on good evidence that has been properly obtained and secured and should be in a position to be led properly before a magistrate or a presiding officer.
There are different kinds of evidence. You've mentioned that earlier. I think Brigadier Mangale and General Ramatswele, if you want to comment on the issues we are raising, you can do so. You don't have to wait for me to say so. I indicate that you want to do so. How many kinds of evidence are there? There's indirect. I know there's indirect evidence and direct evidence. Can you explain this to us?
Okay. Direct evidence is that evidence which is led by a person who has personal and direct knowledge of a fact. For example, if we are talking about a rape matter, for example, sorry, it's an unfortunate example, but a direct evidence can be led by the victim herself or the accused if he so chooses, or any other person who was present when that unfortunate incident took place. So it is direct in a sense that it is tendered by the person who has first-hand knowledge and is not relying on what he heard from someone else. Indirect evidence could be evidence that is led on the basis of objective facts, on the basis of which an inference can be led about the occurrence or non-occurrence of a particular matter. For example, forensic evidence or evidence led by experts who would look at a particular situation. They would look at this glass of water, they would analyze it and confirm that it is indeed water. They don't have to be there when this water was manufactured. But that type of evidence, it is indirect, but it is based on realistic, objective inferences that can be drawn. And that type of evidence is also admissible in a court of law. There is also documentary evidence, which is based on documents. If you're dealing with a fraud case, for example, the fact that someone tendered a false ID, that particular false ID can be submitted into court as evidence, but it is documentary evidence. It is not a living type of evidence, but it can be accepted because it is what it purports to be. It's an ID. You can see that it's Dumile Mateza, but the face on that ID is that of Zola Majavu. So that also is also some type of evidence. There's also evidence that can be obtained on the basis of electronic devices. You can still, and the Brigadier here would confirm, in the event where we allege that certain crimes were committed using a computer or a cell phone, you can still...
Cybercrime, in other words.
Exactly. You can still get hold of that particular gadget and go inside to see at what particular point in time was such a message transmitted from that phone. And in fact, incidentally, in one of the famous cases involving the lady accused of having murdered the judge, one of the final nails to the coffin of that particular case, pardon my pun, was as a result of technology. They were able to plot her whereabouts at a particular point in time based on evidence that was obtained from an electronic gadget. So all of those objective factors that tend to prove or disprove the occurrence or the non-occurrence of a particular incident, collectively viewed, they are referred to as evidence.
General Ramatswili, when a case is presented to the police, somebody comes, reports a murder or whatever case, what is the first thing as detectives that you do?
Thank you, sir. In most cases where these serious crimes are committed, you find that it happened at a particular spot. It's reported in different ways. Sometimes the people will phone in, and then a police vehicle will be dispatched to the crime scene. And at the same time, the detectives who are on standby or who are working in the detective service center, because some police stations do have centers we call detective service centers, which are very close to the client service center where usually crime is being reported. They will be dispatched to the crime scene, and whoever arrives first at the crime scene have to preserve the crime scene and ensure that it is not tampered with. And he will follow all the other steps which will ensure that that crime scene is managed properly. Firstly, for instance, the one who arrived at the crime scene will cordon it and ensure that people who are not supposed to be in the crime scene are out of the crime scene. If, for instance, he is a person from visible policing who is not necessarily an investigator, his first task will be to preserve that crime scene using the necessary cordoning of instruments. And then on arrival of the detective, he will hand over that crime scene to the detective, and the detective will follow all the other relevant steps that are supposed to be conducted at a crime scene.
Let me also pose this question. Who decides what detectives are going to be there? There will be your normal detectives, there will be your forensic detectives. Who decide what detectives we need at what particular stage?
The normal practice is the detectives who are based at station level. Remember, we've got detectives who are based at station level who are doing all crimes. And we've got detectives who are attached to the DPCI who are specialists. They are doing specific crimes. So in most cases, all these crimes will first be attended by the station visible policing member who is wearing uniform, who will activate the detective at station. And if the case is then a case that needs to be addressed by the DPCI will also be called. And all the other relevant roles players like your criminal record center or your forensic services, the detective who takes over the crime scene from the one who preserves it is the one who is going to decide which role players do I need to take further my crime scene. And that's when he's going to activate the rest of the others.
Well, when we come back, we'll pursue this issue further, especially regarding to forensic investigation. But if you'd like to join us on today's discussion, you can please call us on 011 714 5497 or 5498, or tweet us at Rights Recourse, or email us, or anything that you want to talk to us about on rightsandrecourse@sabc.co.za. We'll be back after the break. Well, welcome back. We took our cameras to the streets to get the public opinion on evidence.
You can win a case without evidence.
No, it's not possible, and I don't think any person can win a case without an evidence, because for a person to win a case, you have to have an evidence.
You can't win a case without evidence, because they have to get an evidence in order to see whatever you did, it's right or wrong.
Yeah, I think you can win a case without evidence only if you've got money, because in South Africa, money talks. You see these famous people, when they have money, because they've got money. But the innocent ones, because they don't have money,
well, thank you. Those are the views of the people we spoke to in Johannesburg. But first of all, let me get this. We heard Ronald Bobrov saying earlier in the case, it is evidence that makes the case. In what way? Who decide what is evidence?
Well, anybody who takes to the witness stand goes in there with one purpose in mind, to give evidence. That the issue is whether or not that which is being proffered as evidence is good enough to lead to a particular inescapable conclusion that Dumile Mateza committed the offense with which he is charged. Whether or not you are guilty or innocent is largely and wholly based on the quality of the evidence, which is why it is important to make sure that that evidence which is proffered is of such a good quality that it would exclude any other possible inferences in order to lead to guilt. And the converse thereof is equally true. If the evidence is poor, chances are the accused would walk, because we live in a constitutional democracy, and one of the basic tenets of our law simply says, he who alleges must prove. And in a criminal case, the state must prove the accused's guilt beyond reasonable doubt. So if there is 1% of doubt, that benefit thereof must be given to the accused person. Who decides? Of course, it is a trier of fact. The trier of fact is either the judge or the magistrate or the presiding officer, who has the task of evaluating the type of evidence that has been put before her. And if she is satisfied that it excludes all other possible inferences, a guilty verdict will be returned. But if there is doubt, even if the magistrate or the judge does not believe the particular accused, if there is that 1% of doubt, the accused person must get the benefit, because he's under no obligation to prove his innocence. It is actually the state that must prove his guilt beyond reasonable doubt.
But Mangala in Pretoria, I would imagine that all police have been trained to understand that they cannot tamper with a crime scene if there are forensic issues that the forensic investigators must detect from the scene.
Yes, the police officials are actually trained to evaluate the crime scenes. Hence, it has already been mentioned by General Ramatswili that it is important that the first responder must ensure that the crime scene is secured and cordoned off. And the crime scene manager, which in the main is the detective, must then ensure that he activates all the necessary aids. That would be, if it is the forensic experts, those forensic experts must come. Because they are more expert in the field, it is better for them to collect specific evidence, for instance, evidence relating to fingerprints, evidence relating to ballistics, or DNA, or any other scientific related evidence. It is a common knowledge that the police are trained during the basic training to preserve the crime scene and manage the integrity of the evidence collected. Hence, it is also important that whatever we collect there, we must be able to document whatever we have done there, so that it does not be disturbed or tampered with or contaminated for any other reasons that would disturb the evidence that can be presented. But anyway, the purpose of forensic is not to really pin down a person. It is about including or excluding the person or establishing the facts as to what has really transpired at the crime scene.
One of the things that fascinated me, I watched one doctor who was killed in the United Kingdom, and I saw these policemen, I think it was forensic investigators, wearing completely different clothes as if they come from Mars. Do you have to be protected in that manner so that you don't tamper with evidence?
It is critical. It is critical that the investigator or crime scene processing must be done properly. One of the critical things that we do is to wear protective clothing. This protective clothing is to prevent us to deposit our own evidence there so that we do not contaminate the scene due to, for instance, if we want to extract DNA touch at the scene, if I do not wear the proper mask and protective clothing, then I deposit my DNA there. So in order to prevent foreign evidence at the scene, we must wear protective gears to ensure that we do our work properly, and protective shoes and so on.
Is DNA a form of forensic investigation, the testing for DNA?
Yes. The DNA form critical part of the investigation of crime, because any person can leave his body fluid at the crime scenes, and therefore police are trained to know how to collect DNA at the crime scenes. Of course, it is regulated in terms of how you must collect such type of evidence. However, if it is at the crime scene expert can collect it. However, if it has to be collected from a person, it must be collected by an authorized person who is not a crime scene expert and who has been trained in terms of the National Health Act. To this end, we have trained around 800 police investigating officers to collect buccal swabs. We foresee that at the end of this financial year, we would have trained for around 5,000. And in the next financial year, which is starting in April, we should train around 15,000 of police officials. So we are targeting to train all the detectives as well as the detectives attached to Independent Investigative Directorate.
Let me come back to something. We'll come back to this issue of forensic investigation in cases. Mr. Majavu, one of the things in high-profile cases like the O.J. Simpson trial and the Oscar Pistorius trial, when these trials came to court, many forensic experts said because these trials were going to be, the evidence that was going to be laid was circumstantial evidence, because the only people who were in the crime scene were the accused. Therefore, how difficult it is does not put the prosecution and the police on the back foot immediately.
Well, of course it does. And unfortunately, that is the flip side of a constitutional democracy that is underpinned by the rule of law. The fact that a crime has been committed immediately puts the state and the prosecution on the back foot, because it is they who must confirm the obvious. We know that Dumile Mateza was killed, but it is not so obvious that he might have been killed by Uzola Majavu. In order to lay that matter to rest, they have to rely on all forms of evidence that would point out to the fact that Majavu is the culprit. And the minute there is a doubt about the identity of the culprit, the person who is in the dock will walk. That's a fact. But there have been instances, to be fair to the police, where they have nailed culprits purely based on circumstantial evidence, because of the quality of the evidence that was gathered, because of the proficiency with which that evidence was put out to convince a judge that the fact that there's no direct evidence does not mean a person should walk. But if you look at the indirect circumstantial evidence, it leads to one inescapable conclusion, namely that it is Majavu who killed Mateza. There can be no other inference that can be drawn. But yes, it is not easy, but if you use the crime scene experts properly, if you protect and preserve the crime scene properly, there were instances where a successful prosecution has followed. But the unfortunate truth, and I heard what that Leseja said, I wish the numbers that he had referred to are indicative of the quality of the training. Because in some instances, the very crime scene experts and the investigators, on account of their lack of training or the adequacy thereof, they themselves compromise the case. And once a crime scene is compromised, the evidence that is extracted from that crime scene is the fruits of a poison tree. And therefore, it may either not be admissible, or the evidential weight to be attached to such evidence would be of such a nature that a judge may not be satisfied that the guilt of an accused has been proven beyond reasonable doubt. But the bottom line here is the evidence and the quality thereof makes or breaks the case. You must understand that a case is about two parties: the accused party, who has constitutionally guaranteed rights, and the state. And unfortunately, I don't even have to open my mouth as an accused person. I can just say, bring it on, and let us test that which you have. And I keep quiet because the Constitution says I have a right to be presumed innocent, and I have the right to remain silent from arrest right up to the trial. And when we go to trial, as a defense, I know exactly what evidence is going to be led, who is going to come, what are they going to say. So I can already work around that which the law says must be given to me in advance. And that puts the state in an awkward position somewhat, because there is no corresponding obligation on the accused. You may not even know what the accused has to say, and he may be the only witness. And if he chooses to shut up, that's it.
General Ramatswili, as Advocate Majavu is saying, the issue of training has become very topical in the police force, especially with regard to preparation of documents for court that must go, preparation of the evidence that must go to the prosecutor. What are we doing around that area?
Thank you, sir. There is continuous training in the South African Police Service, specifically those who are doing crime investigation. We have a course which was recently put into place to replace other earlier courses which we used to have, which is a 14-week course, and it's called Resolving of Crime course. The main purpose of bringing that course was to ensure that all the requirements which can make an investigator to be able to handle a case properly are covered. It's covering law of evidence, it's covering criminal law, it's covering crime scene management, it's covering confessions. All those things which you need to prove a case is part of that course. That's how serious we are taking the training of the detectives. From visible policing also, our members are being trained. They are receiving, for instance, first responders course, which actually capacitate them to can be able to know how do I handle the crime scene until such time that the detective arrives, if I'm the first person who happened to be at the crime scene. So that's how serious we are taking the training. But I also wanted to add...
Can we go to that when we come back from the break?
Okay.
If you'd like to join us on today's discussion, please call us on 011 714 5497 or 5498, or tweet us at Rights Recourse, or email us at rightsandrecourse@sabc.co.za. We'll be back after the break. Welcome back as we continue our discussion on the law of evidence or issues pertaining to evidence in court that made a lot of our cases, a lot of the people who are accused of certain things get scot-free. Brigadier Liseja Mangale, is it not true that the technique of doing the tests should be matched by the ability to present that evidence in court?
Well, it is important that when we collect evidence, we recorded it correctly, and to ensure that when we present it in court, we do not present our version. We present the facts of our analysis through which it has been derived from the crime scenes. The point is, it is not always that the crime scene expert who collected and packaged the evidence will be the person who analyzes the evidence as such. There are different expertise that requires different competencies. And therefore, the person who packaged the evidence must ensure that the packaging is done properly, because the person who's going to analyze the information is going to analyze on the basis of how they have received the exhibits. And the evidence then will be presented by the expert who has then analyzed those things. We must strike balance between the collection and the presentation of evidence in court, and it must be equally balanced, and the people must know what they are doing when they present it in court. And we teach our people that it is never about trying to pin a person down, but it's about unpacking the facts as it has been found there. So in other words, it's either to prove innocent of somebody or to prove guilt of somebody. So it is important that our experts present facts, not their subjective opinions.
General Ramatswili, it's been said, I think Brigadier Mangale spoke about it, the training of detectives. We've seen cases, huge cases, and the Pistorius case, for instance, the defense played on this issue of the detectives, the first detectives to arrive on the scene, walked all over the place, and then with no regard for safeguarding this area. And then we had another case in Cape Town, the Diwani case, where the person probably, I will leave that question to Brigadier Mangale, the person who was dealing with the ballistics was actually, did not know how to explain the ballistics test that he had done.
Thank you, sir. Relating to the case of Pistorius, that was actually mentioned by the defense in court, scrutinizing how the crime scene was handled and so on. But the fact is, members are being trained and they know how to handle this, but it happens sometimes that members behave in ways which actually are not in line with how they have been trained. But we always, at the same time, where we pick up that a member handled a crime scene in a way that was not desirable, we do our best to reconstruct.
My apologies, I'm just been asked to take this call from Hlubi so that we get that, we can deal with that question. Hlubi, good afternoon and welcome to Rights and Recourse.
Good afternoon, how are you?
Fine, thanks, how are you?
I'm good. I just want to ask this question precisely because one of the ladies was killed in her house. And after death, immediately after death, the police come and the body was removed just before the detectives came in. I just want to check around there, what did the brigadier say? The detective was not there. Only the police come in the scene of the death. And then after, up until today, now there is no arrest.
Okay, thank you, Hlubi. Let's get a response from both General Ramatswili and Brigadier Mangale.
Thank you, sir. The standing procedure is that when you arrive, like we have said, at the crime scene, you preserve it, you call all the relevant role players who can assist in ensuring that the evidence that needs to be collected is collected properly. The body was not supposed to be removed if it was removed, until such time that the detectives who are doing investigation has arrived, including the Criminal Record Center police officials who are usually doing crime scene with the police, because they have to take, for instance, photos from the body of this person, and those photos are going to be used as evidence in court. They have to take photos relating to the position, how the body of the deceased was found at the crime scene, and photos relating to all other things in that crime scene that can contribute in indicating what actually happened. In other words, things that can make you to draw a logical conclusion, looking at the photos, that from these photos, this is what could have happened. So that was supposed to have been done before the body was removed. And besides the photos, there is a lot of other things which can be done by our colleagues who are supporting us from the Criminal Record Center, relating to, for instance, fingerprints of the possible suspects who are responsible for what happened there. The DNA, which could have been searched at other places, which a normal person who does not know investigation will not collect those things. So there was a serious error in that regard, if that is what happened. But although that thing happened, the investigator and the crime scene experts can still go back and reconstruct the crime scene and try to get the evidence that they need to prove the case. But that is not the golden rule. The golden rule is that we must do it correctly right from the beginning.
I'll come back to that. I'll ask Mr. Majavu to give a view on that. But first of all, I want to go to Brigadier Liseja Mangale. Brigadier Mangale, one of the questions I want to know, isn't it proper, if a murder is reported, all of these facets of the state should go together to the scene to avoid people walking all over the scene? They then say, no, wait outside. I will see. Well, let's cordon off the area so that we then are able to collect the evidence as forensics.
Well, the truth of the matter is that it could be ideally so, but however, if you make a forensic service which is equals to the size of the total police, you would have people that are loitering and doing nothing. So it's important that we balance the resources of the state in such a manner that the people are utilized efficiently and effectively. Of course, we would want to go to areas everywhere where we could, and hence we expanded our services in the main to most of the police stations and the clusters. The detectives and the crime scene experts are normally activated once the crime has been committed. And it's important, like the caller who has just indicated now, that the body was removed before the arrival of the detective or the crime scene experts. It's important that the people must realize that such incidents should not happen before the examiners come, because we need to examine the scene to collect all forensic related evidence in order to ensure that we do not miss critical information or clues that can lead to conviction or exclusion of innocent people.
I want to come back to an issue, Mr. Majavu, that the General raised here, that the scene can be reconstructed. Now, how do you reconstruct a scene after it has been tampered with?
Firstly, yes, it is true that a scene can be reconstructed, but once again, you are relying on conjecture. And the quality of the evidence resulting from a reconstruction would not be as weighty as that which would have been original in its untempered form. And that is precisely where any seasoned defense will go. The question was asked, about the importance of the preservation of the crime scene. I'm going to give you an example of what happened in real life to drive the point. But here's the point. Obviously, if it were to be shown that there is something amiss about how the crime scene was handled in its original form, the defense will make a lot of noise about that with one aim in mind, to say if the crime scene was tampered with, you as the judge should not attach too much weight on that which was extracted from a tampered scene. We colloquially refer to it as fruits of a poisoned tree. And that is where 99.9% of the cases the defense will start. Because if you were to be able to show some doubt or plant some doubt on the crime scene and how it was handled, chances are that which comes from there is either going to be inadmissible or not too much weight attached to it.
Now, let me go back to Brigadier. Brigadier, in the Pistorius case was the issue of the door. Apparently the door was removed and whoever was in charge of the investigation put the door in his office. Now, how then, should the door not be with the forensic team or not in somebody's office, a normal detective?
Well, the door that was removed was taken to the forensic lab eventually for investigation to try and establish the impact and the distance of what happened on the given day. The door is not supposed to be in a personal office. It's supposed to be secured in a place because it become an evidence, a piece of evidence. So therefore, it must be managed as an exhibit, and it must be locked and stored in a secure place, which place is stored there for the purposes of analysis and for the purposes of investigation. Therefore, we can't condone if it's stored away in the office of investigating official, but however, if it is stored with the people that were doing the investigation on it, they need it to do their work. Thank you.
One of the other, unless you wanted to add something there. Okay.
I'll just give you an example of how a crime scene was not properly managed and that led to an acquittal, and I was a beneficiary there. When the late Mr. Eugene Tereblanche was murdered, it is common knowledge that the crime scene was not properly secured. People, including journalists, walked in, took photographs, and posted it all over on the social media, disrespecting the rights of the affected family, but undermining the actual investigation, because the people who got to the scene first did not even take samples. There was clear semen that was on the body that was not taken, collected, and analyzed, because that could have also indicated or pointed towards DNA that would lead you to a perpetrator or to exclude other possibilities, but that was not done. By the time all other stakeholders were activated, we're talking 4 or 5 hours later, because they had to come from Pretoria to go to Ventersdorp. And because of the shoddiness in which the crime scene was handled, a lot of crucial evidence that would have proved the guilt of certain people was excluded. Another example was even how you treat accused. In that instance, a minor accused was arrested by the police who had no clue about how they should handle a minor. This minor made a confession and pointings out, because he was taken back to the scene to say, show us what at Visogebier, and those pointings out were done. And when we went to court, because they did not follow the correct processes, they violated the provisions of the Child Justice Act, even those pointings out were thrown out. And the pointings out are also evidence. So the point of the matter is, it's not only the collection, the preservation, and the handling of the people from whom the evidence is extracted. If you don't do it well, you might as well close shop. And that's what happened.
Well, we'll continue our discussion. I just want to, when we come back, to emphasize this issue of how many experts, forensic experts there are in the police. If you'd like to join us on today's discussion, can please join us. Call us on 011 714 5497 or 5498, or tweet us on Rights Recourse. We'll be back after the break. Welcome back. Before we get into the meat of our discussion to the other questions I needed to ask, let's take this call from Majoro from Welcome. Majoro, good afternoon and welcome to Rights and Recourse.
Hello, sir. Good afternoon.
Yes.
My point is that, especially with the police, I comment mostly on their statement. They are verklaring. Most of them, they don't have a passion and they don't have a clue of how to write the verklaring. In the first place, when you write the verklaring, you are in the side of law, you are in the side of state, you protect your work, you protect your state, you protect everything. But most of them, they don't even understand what they are writing. If you read most of the cases in the court, if you listen to them, most of the cases are gone free of charge because most police, they don't have a clue of how to write the statement. Die verklaring is baie belangrik en polisiestasie. De mensen moeten dit weten hoe om dit te schrijven. Mensen moeten dit weten.
Thank you, Majoro. Thank you. Thank you, Majoro. Bye, donkey. Bye, donkey, Majoro. General, let me put that question to you. What Majoro was saying sounds to have been he sounds like a former policeman because he knows about a verklaring.
Thank you, sir. Yeah, the issue of statement taking has been raised several times, and to address the problem, management of the police has put specific corrective measures into place. We have now courses in statement taking, but remember, this statement taking does not mean that a policeman or woman is trained to take a statement only when she arrives at the police station. They are being trained to take statements already at basic training at the college. And when they go out of college, when they arrive at the police stations, they've got members who are supervising them, who must ensure that the statement that has been taken is having the necessary elements of a crime so that when you register a case, it makes out an offense. Because if the statement does not have all the necessary elements of a crime, then what charge do you register? So that part has been identified and there is measures in place to try to correct it. But there are also at the same time police officials who are taking very good statements. So it depends from person to person. There are those people who's got passion in what they are doing, and there are those people who don't have passion in what they are doing. Besides the fact that the person has been trained, but the person does not make those efforts to do what we expect should be done. But
let me go back to something else that I wanted to raise with Brigadier Liseja Mangale down in Pretoria. Brigadier Mangale, in a report that I read in the Citizen yesterday on this very issue, the report was profiling Captain Mangena. The report says there are 10 experts in this field, in his field, from Gauteng, from Mpumalanga, for Northwest, for Western Cape and Free State. Is this issue being addressed?
Well, I do not have the actual figure, but the 10 is not correct. The ballistic environment is a big environment, which has a representation in the Western Cape, which has a representation in the KZN laboratory, the Eastern Cape laboratory, as well as the laboratory here in head office. So it is an environment which is big. There is more than 50 people in that environment, so they cannot be just 10 experts countrywide.
Another problem, Brigadier, is the problem of the forensic science laboratory. Cases take very long to come back from the forensic science laboratory. A simple blood test, for instance.
Well, many a times people confuse the blood tests that are done by the South African Police Services and those that are done by the Department of Health. We have shown that our response time has improved drastically. whereby most of our cases in relation to DNA, 78% of them are finalized in 28 calendar days, which implies that our response time has been bettered. We must say, of course, there are research cases that take a bit longer, which are not routine in nature, that needs more expertise and more chemistries that needs to be done. But in general terms, we are well content with what we are doing, and I think we are doing a good work in terms of analyzing and responding to the case. I don't think we are delaying the court processes that much with regard to ballistics, with regard to chemistry, with regard to fingerprints-related evidence, and even biology for that matter. We are not necessarily really delaying courts. We are doing good work in that regard.
Well, when we come back, we'll look at the issues that what can be done to solve this situation so that we don't lose so many cases in court. We'll also touch on what contact the police have with witnesses before they go and testify in court. If you'd like to join us, you can still call us on 714-5497. Probably before we go to the break, let's take this call from Sipiwe. Sipiwe, good afternoon and welcome to Rights and Recourse.
Good afternoon, sir. How are you?
Fine, thanks. How are you?
I'm good, sir. No, I just want to find out how important for the police to go to the place of the scene. Because at one stage there was a break-in in my flat. The police did not even come to my place to investigate the place. I used to find the investigator sitting in his office, and every time he used to tell me that there is no evidence for my case. But he was not once in my place. He don't even know where I stay. So how important for the police to get to the place to investigate how the break-in, because there was a break-in in my flat. And eventually, I ended up giving up on the case.
Thank you, Simpiwe. Thank you very much. We'll get General Ramatswili to respond to your question after the break. If you'd like to do like Simpiwe has done, you can call us on 714-5497 or 5498 or tweet us at Rights Recourse. We'll be back after the break. Welcome back. I would like to ask, without waste of time, General, I want to respond to Simpiwe.
Thank you, sir. Sipiwe, it's extremely important that crime scenes, all crime scenes, should be attended, specifically yours, in the sense that it's a housebreaking case where, in most cases, there is no eyewitness who could have witnessed what happened. I would suppose that you only managed to find out a day later that something happened at your house. So the only evidence then that could help us was that evidence that could have been gathered at your house, like your fingerprints, your DNA, your footprints, and other things that can assist in identifying the person who committed the housebreaking. So it is extremely important. But there should always be steps taken by victims of crime if something like that happened. You always have a commander at the police station who is in charge of the member who failed to come to your house. So in the future, if that happened, go back to the police station and question who is the commander of the detectives at this place and lay your complaint so that it can be addressed to stop that member repeating the same mistake.
Let us get final comments from Brigadier in Mangale in Pretoria. Brigadier Mangale, obviously there are huge gaps in the area of forensics in the police. How can these be addressed in 30 seconds?
Well, the forensic services is continuously being capacitated in terms of resources, be it human or physical, so as to ensure that we cover the ground. But what is also important is to do forensic awareness to the community, because crime is committed to the people there. If the community can just become aware that they should not disturb the crime scene, that would go a long way in assisting us in discovering what has actually...
Thank you, Brigadier. Let's get forwards from you, Mr. Majava.
Language is very important, and oftentimes people pretend that it is not important because statements, the verklaring is taken in a particular language. And there is this temptation or this notion that verklarings must be either in English or Afrikaans. There's nothing wrong in taking good statements in the language in which either the complainant is proficient in or the witness. So I think it's about time that the police must also, as part of their capacitation, to capacitate members also take statements in other languages as well. It will assist them. As a matter of fact, the Section 35 notice is written in 9 official languages and it stays in the police stations.
Gentlemen, thank you very much. It's also a rather riveting discussion. I think we have not touched the core of the issues we intended to touch here today. This has been Rights and Recourse. This program is repeated at 10 tonight and 5 on Monday morning. From all of us in the studio, thank you to our guests and good afternoon.